What do we mean by data portability in our report? First of all, it is important to note that there are various ways to promote data access and sharing. And on this slide, you see a taxonomy that shows the various ways of openness of data, covering conditional access to data and open sharing arrangements. For instance, you see level 3 as open data, which is so-called open access. In contrast, you will find discriminatory access by stakeholder, and this is the category where data portability sits. The specific definition that we proposed in this report is that data portability should be understood as the ability of a natural or legal person, and this includes businesses, to request that a data holder transfers to the person or to a specific third party data concerning that person. So this is the definition that we used in this report and which was adopted across the OECD. Another requirement here is that the data is provided in a structured, commonly used, and machine-readable format on an ad hoc or continuous basis. So the other benefit of this report that it provides key dimensions under which data portability arrangements and initiatives can be categorized. This taxonomy, which you see on this slide, provided us a clear indicator on how to map and analyze data portability initiatives in the public and also in the private sector. We also ran a survey of private sector companies to have a greater understanding of data portability initiatives, and the report outlines the findings of that survey. So let's go through this taxonomy. Under sectoral scope, we examined whether data portability arrangements or initiatives are sector-specific and thus only directed to holders in a specific sector, or are horizontal and directed potentially at all data holders across sectors and domains. Under beneficiaries, we looked at whether only natural persons have a right to data portability, or whether also legal persons, including businesses, have a right to data portability. Type of data subject to data portability arrangements looked at whether data portability is limited to personal data and whether it includes or excludes volunteered, observed, or derived data. Under legal obligations, we examined the extent to which data portability is voluntary or mandatory in a country, and if so, how it is enforced. And lastly, under modus operandi, we examined the extent to which data transfers are limited to or include ad hoc one-time downloads of data in a machine-readable format. So this is what we called data portability 1.0. Ad hoc direct transfers of data to another data holder. This is what we call data portability 2.0. Or real-time continuous data transfers between data holders that enable interoperability between their digital services. And this is what we called data portability 3.0. So, in our report, we looked at different data portability initiatives in the public and the private sector. Some were established in 1996, such as the US HIPAA. We also looked at recent data portability initiatives, including the California Privacy Rights Act. What was really fascinating for us when we looked at these initiatives, and this underlined the validity of our taxonomy, is that we can see an evolution from data portability 1.0 to real-time continuous data transfers, which we distinguished as data portability 3.0. If we, for instance, highlight the California Privacy Act, we see this real evolution there, as the 2020 Act was under data portability 1.0. However, the new legislation, which complements the California Privacy Rights Act, will be already under data portability 2.0 and introduced ad hoc direct transfers as a complementary mechanism for data portability. Obviously, we need to briefly touch upon the GDPR, which upon entry into force in May 2018 formalized the right of data portability within the European Union. So whereas the directive that preceded the GDPR gave data subjects the right to access their data, the GDPR went a step further and granted data subjects a separate, distinct right of personal data portability. That right in Article 20 of the GDPR provides that data subjects, and I quote here, shall have the right to receive the personal data concerning him or her, which he or she has provided to a controller in a structured, commonly used, and machine-readable format, and have the right to transmit those data to another controller without hindrance. I would note here the EU Digital Markets Act and the Data Act proposal, which can be categorized under Data Portability 3.0, and which were not analyzed in our report, but we will do so in our upcoming work that will exactly look at the competition angle, which you mentioned, Claudia. It is interesting also to highlight the data transfer project, which was launched by Google, Facebook, now Meta, Microsoft, Apple, and Twitter, and created a standard-setting initiative, most likely in anticipation of the GDPR right to data portability. The data transfer project was launched as an open source service-to-service data portability platform so that all individuals across the web could easily move their data between online service providers whenever they want. The data transfer project was motivated by the recognition that portability and interoperability are central to innovation. In particular, the data transfer project aims to enhance the data portability ecosystem by reducing the infrastructure burden on both providers as well as users, with the goal to increase the number of services that provide portability. So there are a lot of opportunities of data portability which we detail in our report. For instance, data portability can be one tool to promote interoperability across different online platforms, increase consumer control over their data, enhance competition and innovation, and reduce switching costs and lock-in effects. It can empower users, so us, to play a more active role in the sharing and reuse of our data across digital services, online platforms, sectors, and borders. For instance, the ability of the data subject to download their personal data collected by a data controller could increase transparency and allow data subjects to determine whether they wish to take further action to exercise their privacy rights, such as correction or deletion. We also saw significant risks, though, with data portability. Firstly, major differences across data portability initiatives have led to uncertainty for market participants. The major differences of such initiatives relate to their scope, such as who has the right to have data ported, what data can be ported, whose data should be portable. There are also purpose exceptions to mandatory porting and possible consequences for non-compliance. The issue of scope may also raise the issue of whose data should be portable, especially given that data are often associated with more than one person, such as in the case of emails, pictures, videos, wedding lists. It is an implementation challenge for data holders to account for each individual's rights. Secondly, data portability regimes may heighten issues and concerns around digital security and privacy. And this is very important because enabling the transfer of personal data between organizations on data subject requests may increase personal data flows, confuse individual conception of how their data are collected, processed, and used, and in some cases may prompt them to limit or refrain from certain activities online. So that's why we think the trust in any data portability regime should be fostered so the potential benefits of data portability are more likely realized.